All right. Again, thank you so much for joining us. We are really excited about this topic. This is something Betsy has been working on for many years. And obviously a topic that is one area in the system that is just really broken. But before we get started, I just want to introduce the team. For those of you who are familiar with the AOT implementation team, we have a new member. Shanti Silver is our, I can't remember your title. I can't remember my title for that matter. She's our AOT research associate. And her role is going to help us with program evaluation and making sure that we and you all are aware of research that is that pertains to AOT. And then we have the regulars. We have Brooke Gentry, who is our AOT implementation coordinator, and today's speaker, Betsy Johnson. Betsy has been she's been fighting for people with severe mental illness for, well, more years than she probably wants me to say. Prior to joining TAC, almost 9 years ago, I think, we're coming up on 9 years. She spent 10 years at NAMI, Ohio, working on a number of issues, but passing the AOT law in Ohio. And she joined TAC in order to get people to use the law in Ohio. And she's been extremely successful with 34 programs. I got to keep counting, 34 programs in Ohio. When she started, there were probably 4. So she's been very successful at that. This work with dismiss upon civil commitment, she took on a few years ago and produced a paper of, we didn't call it dismiss upon civil commitment back then. It wasn't even dismiss. It was using AOT to respond to the Competency Restoration Crisis. She took that work and then built on it and grew it into this handbook that we released in March. And I think it's an amazing piece of work, and I know the network will find it very, very helpful. I also want to acknowledge, before I pass it off to Betsy, that we got advertising for this webinar in places beyond the AOT Learning Network. And so welcome to all of you who are not members. I encourage you to join our learning network. We do monthly webinars that are related to AOT, and then we do stakeholder specific web chats. We try not to bombard your email box, but when we did a survey, those that responded thought both the emails and the network were extremely helpful. So do join us. And I noticed there's some raised hands. If you have questions, please put it in. Is the handbook released in March available? Absolutely. Brooke will put that in the chat as well. So Brooke did add the link to join the network. She will add a link to the handbook. And we are we will be taking questions after Betsy's presentation, and you can use either the chat pod or the Q&A pod. We'll be monitoring both. So again, thank you for joining us. I'm going to pass it off to Betsy.
Great. Thank you, Amy. Good afternoon, everybody. I looked at the registration list before hopping on today, and I think I know probably at least half of you personally. For those of you I haven't had a chance to meet, welcome. Thanks so much for spending some time with us this afternoon. So I know the title of this webinar is really long. Dismiss upon civil commitment with AOT, an alternative to the competency restoration crisis. And we really tried to shorten it, but decided just to keep it right like it is, because it's important to, I want to distinguish, this is not the same. A lot of folks are using the term dismiss and transfer or dismiss and refer. We think it's really important that we clarify what we're talking about. It's not just dismiss and transfer to civil commitment, but it's only dismiss and transfer to civil commitment if there is an AOT, an effective AOT program in which to discharge those individuals to. It's not enough just to put somebody in a hospital and expect them to be able to be successful in the community without some long-term treatment and sort of wrapping around those individuals. And the second part of the title, an alternative to the competency restoration crisis. That's the competency restoration crisis is huge. And this is not the magic solution to that entire crisis, but it really is one alternative to a subset of those folks. And we think it's the best alternative. So we'll talk a little bit more about that as we go. Oh, no. Oh, shoot. Brooke, what am I doing wrong? It's not moving.
Try, are you clicking?
I am.
What about pressing the right arrow key?
Yeah. Oh, there we go. Okay. I think I did that, but it didn't work the first time. Okay. So I just wanted to point out, so if you're not familiar with the Treatment Advocacy Center, we have a brand new website, a new logo, and we have a new slogan on the front page, which I love. We used to have sort of this long, complex mission and vision that talked about legal barriers and all that, and I never quite committed it to memory, and I always felt guilty about that. But now when you open up our website, you'll see on the front page, it says, fighting for the lives of people with serious mental illness and a system stacked against them. And that's exactly what we're all about at the Treatment Advocacy Center. And I wanted to talk a little bit about language. So we use the term severe mental illness, which is a little different. Most people use the term serious mental illness, and we do. There is a difference. So when you hear serious mental illness, typically we're talking about that population of individuals with serious mental illness that's a little bit larger. I think that it's estimated to be about 5.5% of the general population. We use the term severe mental illness, and it's a subset of that. So it's about 3.8% of the population. So we're talking specifically people with schizophrenia, schizoaffective disorder, severe bipolar disorder, major depression with psychotic features. So kind of that schizophrenia spectrum. So it's a little bit smaller. And of course, we estimate at least 25% of the severe mental ill population have a co-occurring disorder. Of course, we all know it's probably higher than that, but so just wanted to clarify that's who we mean when we use the term SMI. And the vast majority of the population that we, sort of the sickest of the sick, have this condition called anosognosia. If you're not familiar with that, it's really just a fancy term for lack of insight. Individuals, this doesn't mean these individuals are in denial that they have an illness. They truly don't believe that they're ill. And it's one of the most common reasons folks with serious mental illness don't seek treatment. And of course, why would you? If you don't believe you're ill, you're not about to go to a doctor or take medication for which you don't think you need. We have this fantastic little 3-minute video. I'm not going to show it to you today, but we'll send out these slides to you afterwards. And so when you get them, we've got the link to this video, but it does a really nice job of describing anosognosia, and it talks about brain scans and all that I'm not going to attempt to try and do here for you today. But you can actually see anosognosia, this lack of insight on brain scans. It's estimated actually by Dr. Javier Amador, if you know him. He's the author of I'm Not Sick, I Don't Need Help. But he estimates, and other researchers do as well, that approximately 30% of the SMI population have a severe lack of insight. And then another 30% have sort of this lack of insight, at least, periodically throughout the years of their illness. So it's a substantial number of people that have anosognosia. So what happens to this population? These are the folks that get caught in the revolving door, a term that we use frequently here at Treatment Advocacy Center. They're the folks that are in and out of the hospital, in and out of homelessness, in and out of incarceration. Some folks use the term frequent flyers. Folks who are more politically correct use the term familiar faces, and we at Treatment Advocacy Center call them candidates for AOT. So today we're going to just touch on a few things. We're just going to quickly make sure we're going to do some level setting, talk a little bit about this crisis. We'll talk to you a little bit about what we mean by dismiss upon civil commitment with AOT. For those who are new to AOT, because we know that we've reached some other folks that aren't part of our network. So we're just going to kind of go over a few highlights of what AOT is. So for those of you who have been doing this work for some time, I apologize, but it might be a nice review and you might learn something that you didn't know before. And then we're going to talk about the pathways for dismiss upon civil commitment with AOT. And we'll go through a little bit of a flow chart. And then we're going to talk about next steps in terms of things that you can do if this is something you think would be of benefit in your community. So just in terms of the crisis, Amy introduced Shanti Silver earlier. We're really excited to have her on our team now, but she is a co-author along with a former colleague of ours, Elizabeth Hank, of this report that was issued, I think, in January of 2024. It's available on our website. And again, I've got the link here. So when you get these slides, you can click on this. It's a phenomenal report. And it really delves deeply into kind of what the situation is with our state mental health hospitals around the country, and actually goes through state by state. So you can kind of see how your state stacks up and what percentage of beds are available for your population and how you compare to other states. But the thing that's so, in my mind, kind of just mind-boggling about this report is it looks at this issue of the forensic population versus the civil population and what it's done over recent years. And you can see on this chart that the number of forensic beds have gone way up since 2010, and the number of civil beds have gone way down. In fact, the proportion of beds occupied right now for forensic patients has gone up actually 58% since 2010. And the number of civil beds have gone down 29% during that same time period. So it's a real crisis. It means that there are fewer beds available for people who have not committed a crime, people who don't have insurance and can't get into private beds or community mental health hospitals, people who are too volatile to be served in the community hospitals. I mean, a lot of those hospitals are not, able to handle somebody who's sort of in the throes of psychosis and maybe, having some volatile kinds of consequences from that. It means that more people are waiting in jail. The wait time, according to this report, the wait time right now in jail, here, I just skip to the next slide. The wait time for people in jail is on average, according to our report that I referenced earlier, is on average 2 months. People are waiting to get from jail, waiting to get into a state hospital to be restored to competency, which is pretty mind-boggling. And then also it increases the risk for victimization. If you're in jail for that period of time, increases your risk of victimization, getting additional charges, self-harm, suicide, and other consequences. Amy mentioned earlier that I was at NAMI, Ohio before joining Treatment Advocacy Center. And when shortly after I arrived there, I received a call from a woman. Her name was Faith, which turned out to be pretty amazing because she really had a lot of faith. And despite all the bad things that were happening to her daughter, she had an adult daughter with serious mental illness who was doing okay. She was living in a group home and was managing, and things seemed to be going, pretty well for her. And she met a gentleman, also was somebody living with serious mental illness. And so he took off for a night on the town, had too much to drink, and had gone to the next town over, which happened to be in a different county where folks weren't familiar with her. And they were walking down the street and they were inebriated and really just making a scene. So the police, who didn't know her, picked her up and brought her to jail. And she sat in jail for a few weeks without any kind of treatment. And consequently, her behavior got worse, her symptoms got worse. And at one point, she actually hauled off and slugged one of the correctional officers. And so they had determined that she was unable to, needed to be restored to competency. So she waited longer, and then eventually a hospital bed opened for her. She went to the hospital, was there for several months. Finally, was restored to competency, came back to jail to answer her charges. Her case wasn't up right away, so she had to wait in jail without treatment. Her case, her mental health continued to deteriorate, and ultimately they just ended up dismissing the charges and sending her home because at that point she had done as much time in the system as she would have had she been found guilty of her crime. It was really just a sad situation, and she lost her housing, so it was had to wait, and they finally eventually she did stabilize, and they found a placement for her. So it's just a terrible situation that could have been avoided, in our opinion, had this option been available in that town. Let's go. So the state has been, states around the country are responding to this crisis in different ways. I know here in Ohio and in other states, they've prohibited the placement of individuals who have committed misdemeanors from being placed in the state hospital. So instead, those individuals are being restored to competency in the community, or their cases being dismissed, and then they're being referred to for civil commitment. Other states have created jail-based competency restoration programs, which to me, feels a little bit like they're guilty before, being proven innocent. They're stuck in jail waiting to be restored to competency, which just doesn't feel right to me. But I know some folks think that that's a good alternative. Others are just dismissing charges outright. They're just dismissing, and the individual is going back into the community. And of course, we know what's going to happen. They're just going to reoffend and come back. So that certainly is just a very short-sighted solution, in my opinion. And some states are actually passing laws to encourage this dismiss to civil commitment. And some are going so far as to encourage dismiss to civil commitment with AOT, and they actually specify AOT in their laws. In the handbook that was referenced earlier, we have actually listed out those state laws, so you can take a look at those. But I think it's important to note, though, here that it's not necessary to change your law in order to use this option. Already, prosecutors have the ability to dismiss charges if they don't think that they're appropriate. So you don't need a law that allows it, although it's nice to have a law that that encourages it and that spells out how to go about it. So what do we mean when we say dismiss upon civil commitment? What we're saying is Dismissing the criminal charges either prior, the person's going to be arrested, they're going to have criminal charges. We mean dismissing them prior to or in lieu of competency restoration, either with or without prejudice. I'm no attorney, and it always took me a while to get my arms around this, but without prejudice means that you can dismiss, or you can refile, and with prejudice means you can't refile. I think that's right. But it means basically holding them, aside and then refiling later on if the person doesn't do well in the alternative program, or just dismissing them outright. And then filing at the same time that the decision is being made to dismiss the charges, and at the same time you would file a petition in civil court. Typically it would be the prosecutor or the court for civil commitment with assisted outpatient treatment. And then once the person is stabilized, which may require a short stay in the hospital, not a long lengthy stay like it would if they're being restored to competency, but just a short stay long enough to be stabilized, and then discharging them to the AOT program. And we're going to go into this a little later in the presentation. We're going to kind of walk through step by step what that looks like. So there are certainly plenty of benefits to a policy of this nature. As we talked about earlier, it avoids that lengthy stay in the hospital. Again, there might be a short stay to stabilize the individual, usually in a local hospital, and then they'll be released back to the community under AOT. So it frees up beds at the state hospital. It reduces the length of time that somebody would wait in jail for a place at the state hospital, because they no longer have to go there to be restored to competency. It ensures that there's long-term treatment available to the individual in the community, and then it monitors them to ensure that they're adhering to their treatment plan. It reduces the risk of expensive lawsuits for violating somebody's civil rights by keeping them in jail beyond the period of time that they are allowed under law. It saves a lot of money in costly restoration services, hospitalization, jail time. And as I mentioned earlier, it doesn't require legislation to implement. So who would be a good candidate? As I said, this is just one alternative to the competency restoration crisis. This isn't intended for everybody, but a subset. So let's talk about who would be a good candidate. So it's somebody who meets criteria for civil commitment under your state law. Most of the folks are familiar with what your state law civil commitment looks like, or criteria looks like. It's relatively consistent from one state to another, but not all states look the same. They're not a risk to public safety. So we're not talking about folks who are violent. These are folks who have committed oftentimes just nuisance crimes. Most common is probably trespassing, but other nuisance crimes, public intoxication, any number of things that you've probably seen. So these are individuals who are not a candidate for mental health court. So assisted outpatient treatment is not mental health court. If you have a mental health court option available and the person is willing to volunteer to go into that program, we would strongly recommend that as an option. But many of these folks, as I said, have anosognosia, so they're not likely to volunteer for a program for which they don't believe they need. They're unlikely to be restored to competency within that window of time. As you know, that you have only so much time depending on what the charging offense is. It's generally between 90 days and maybe up to a year, depending on what the nature of their offense was. They have to be able to understand what's expected under a civil court order. So if they've got a intellectual disability or a traumatic brain injury or something that might prevent them from understanding what's expected, then we would not suggest that they would be considered for this alternative program. And then also they have a history of lack of adherence to treatment due to this lack of insight. So we talked a lot about AOT, and as we said earlier, I know some of you aren't as familiar with it as others in the learning network. So we'll just quickly kind of go over what we mean by AOT. So AOT is a tool in the toolbox for civil courts and mental health systems to work together collaboratively to help individuals caught in this cycle of hospitalizations, homelessness, and incarceration, often due to that diminished awareness or that lack of insight into their need for treatment. It motivates the individual and the program to engage in treatment through, by assigning, developing a treatment plan for them, assigning a treatment team to them, and getting the support and encouragement from the court. And then it ensures that the treatment providers work diligently to keep the individuals engaged in effective treatment. So it's not just the individual who's under this court order, but the treatment providers too are expected to follow through with providing the treatment that's been identified for this person. How does it work? A petition is filed in civil court. Some states refer to it as an affidavit. There's an evaluation conducted by a qualified medical professional. There's a hearing held in civil court, and the individual is afforded all due process rights. They're assigned an attorney. There's clear and convincing evidence that they meet the definition for civil commitment and AOT. That's evidence that's provided by the qualified mental health professional. And then this is assuming everything goes as we hope. AOT is then ordered, and then the needed treatment and services are provided by the treatment team. There's a treatment plan that's developed to meet the specific needs of that individual. Not unlike anything the mental health system does already for individuals in need of treatment. It's individualized. It's not a one size fits all. And hopefully the individual is in a position and wants to participate in developing that treatment plan. Some states actually have the treatment plan part of the court record, others do not, but it's something that's shared with the court. And then adherence to that treatment plan is monitored very closely. And if necessary, they can intervene if things start to go south quickly. Ultimately, eventually, the person engages in treatment. So when I say engages in treatment, that doesn't mean they had just adhered to their treatment plan. They actually have to engage in treatment. They have to demonstrate that without the court order, they're going to continue to participate in treatment voluntarily. So that's sort of a two-pronged test. And then eventually then the order would be dismissed, or the team may choose just not to continue the order. Hopefully there's a graduation ceremony, and the person is then kind of handed off to the treatment team to continue with the services. There are consequences to non-adherence. Oftentimes we hear, oh, AOT has no teeth. It certainly doesn't have the same teeth that a mental health court might have, because remember, these are individuals that may have committed a crime, but those charges have been dismissed. So they're not criminals at this point. So we certainly wouldn't treat them as such. The whole goal here is to get them out of the criminal justice system. So it would be, pretty silly to want to put them back in jail. So, but there are consequences. They do, not unlike mental health court or drug court or some other specialty docket set up there, they have periodic check-ins with the court, typically a judge or a magistrate, checking in on them. Some do it weekly, some do it monthly, some do it, quarterly, just depends. And sometimes it looks different for different people. The time in the program can be extended. So if they're in for 180 days and they're struggling with their treatment, they're not showing up to their appointments regularly, they're not taking their medication as specified in the treatment plan and prescribed, then the team could choose to extend that order. If they start to decompensate and other interventions have not worked, they could be transported for evaluation. And this is where having that court order can help make that easier and quicker, because there's already this existing court order. And then if after evaluation, it's determined that they need to be rehospitalized, then that will be the plan. So the worst case scenario is rehospitalization if they don't adhere to treatment. Again, I left this in for you when you receive these slides that you can link on this. This is a short video, is maybe 4 or 5 minutes, but it shows what AOT looks like from the beginning, kind of from somebody, you know, in the hospital to somebody graduating. It's a great video, so I encourage you to check it out. But if you're not familiar with how AOT works, this will answer a number of your questions. So just one last quick refresher before we move back to dismiss upon civil commitment with AOT. So just to remind you, AOT is involuntary. It's not like mental health courts where somebody can choose to participate or not. AOT is involuntary. Now, some folks get a little confused because they say, well, the person agreed to participate in the program, and if they agree, that's fantastic. You know, we really encourage you know, the treatment team or case manager to go and talk with the person up front, let them know they're being considered for this program, let them know all the benefits to participating in AOT, that they'll have support and services in place. And they may very well say, yeah, you know, especially when they're stable in the hospital and they want to get out, and they think that this will get them out quicker, which it could. You know, they may say, yeah, I'll do that. But even if they don't say that, they can still be ordered into AOT. There are 48 states that have AOT laws on the books. There's 2 states, Connecticut and Massachusetts, that we're still working in to get some laws passed. Just last week, the Maryland Senate passed a bill, and which had already been passed by the House, so it's awaiting the signature of the governor of Maryland. So we're very excited that we just now have two more states. And while it's important to recognize that AOT laws vary from state to state, particularly in terms of, you know, there's the criteria and then the time frames for filing various paperwork and the length of time that somebody's in the program and that sort of thing. So it's important that you become familiar with your state law. There are full due process protections in every state. This is a formal, you know, court hearing in the civil court system. So all those due process protections are in place. There's the ability to return quickly to the community under this scenario. So if somebody's in the hospital and it's known to the team that this individual is coming out on an AOT order, likelihood that they may be able to get out a little sooner. It's the least restrictive setting in many instances. I know there were some advocacy groups that said that AOT was the last resort, which just boggled my mind, because the last resort is incarceration or hospitalization or even guardianship, but certainly AOT is far less restrictive than any of those options. So and much more desirable. The individuals getting the treatment that they need. Again, it's individualized. Some may require ACT level of care, others may not require much help, much treatment at all, or all. That's just a matter of, you know, monitoring their medications and making sure that they're following through with that. So it just varies from person to person, but that adherence is monitored. A lot of folks on AOT are put on long-acting injectables just because it's easier for them and also easier to monitor. There's this ability to intervene quickly. So somebody's on the order, they're starting to decompensate. They've got that team in place. They've got somebody who's identified as the monitor. If they start to decompensate, we can, you know, notify the court if necessary and get them back on track as quickly as possible before they go into crisis and require, you know, either hospitalization or incarceration. Both the participant and the treatment team are held accountable. It's really important to note this because these are folks that are hard to serve. These are the folks that have fallen through the cracks because they don't show up for their appointments. They don't take their medication without some assistance oftentimes. So knowing that you're going to have to appear in court on a regular basis, the treatment team is, has kind of prioritized these folks and really wrapped around them and really gone the extra mile to get them engaged in their treatment, because they too are going to be answerable if things don't work out well. And then the degree of judicial engagement is another thing that varies from program to program, as well as the participants. So different programs operate differently. As I mentioned, I know we've got in Ohio, we've got sort of a huge range. We have one program that sees folks on a weekly basis initially, and then they may go to every 2 weeks and every month and then every 6 months. Another program only sees folks when there's the court only sees them when there's either an issue, they're starting to decompensate, or they've done something extraordinary and the court wants to congratulate them. Otherwise, they just see them every 6 months and extend the if there's a request to continue the court order. So that varies, and you just develop a program that works around what your community can offer. Does AOT work? We've got a lot of data that shows absolutely it does. Some of the richest data comes out of New York State. New York State passed Kendra's law in 1999. It was when AOT really kind of came to the attention of the public. But their state law requires every 5 years that they do a robust data collection. Everyone put together a report to their legislature. So we get a lot of great data out of New York, and you can see here significant decreases in homelessness, hospitalization, incarceration, suicide attempts, and cost savings. We've got the link on here so you can check that out for yourself. So there are 3 ways that somebody can go get into AOT. There's the step down, which is the most common. That's upon discharge from the hospital. There's step up, which is coming directly from the community, where somebody's struggling in the community but doesn't meet hospital level of care, but meets all the other criteria for assisted outpatient treatment, can be placed in the program. That's a little bit more difficult because they're not engaged in treatment, so you don't have the documentation to make the case to the court, but it can be done, and we have several examples of programs who do it very successfully. And then the one we want to talk a little bit about more here is the sort of step over, and this is as a diversion from jail and including as an alternative to competency restoration. So how this works. And this may be a little bit simplified, but we'll just kind of quickly run through this. So a person with severe mental illness is arrested and found that they meet the criteria for serious mental illness, which is again is going to be outlined in the statute. They're unlikely to be competent to stand trial. There's been just a brief sort of not a full assessment, just a quick assessment there, and that's been determined by the jail staff or the mental health staff at the jail. They meet criteria for civil commitment, again spelled out in the statute. Some states have one definition for inpatient hospitalization and another definition for assisted outpatient treatment. Other states have it all in one definition. So you want to make sure that they meet, that they meet criteria. And then lastly, they're not a public safety risk. So this is not an alternative for individuals who have been picked up on a violent crime. We're not looking to put them in assisted outpatient treatment. That's not the goal here. So that's an important question to ask. So once it's been identified that they meet this criteria, then you decide, does this person need to be hospitalized? Because if they do, they should go to the hospital immediately. This is this process should not interfere with the need to, for somebody, the ability for somebody to get the treatment that they need right away. So they're hospitalized if needed. And then at that point, then the prosecutor is presented with the situation and makes a decision. Is he or she willing to dismiss this case upon civil commitment with AOT? Ideally, they're going to, based on all that information they've been presented with, they'll make the determination that yes, this person would be better suited for the civil justice system. And at that point, a petition would be filed in civil court. It could be filed by the prosecutor. It could be filed by the court. It could be filed by the hospital if they're in the hospital, or it can be filed by the mental health system. But that needs to happen. And then at that point, there's a hearing. And then civil commitment with AOT is then ordered, and the criminal case is dismissed. So we're going to go into the. And then if the person, the question that needs to be asked is, is a person engaging in treatment? Again, it's not the same as a person adhering to treatment. They need to be engaged. So we've heard of situations where somebody who's been on AOT for years does a fantastic job, is doing great in the community, is, there's no issues. But whenever she goes back to see the psychiatrist, she tells him, you know what, doc, the only reason I take my medication is because the court orders me to. So that's all we need to hear. And then the doc says, recommends that the case be continued and so on and so forth. So she's been in there for years, never fully engaged, but is doing well under the program. That's not common that happens, but it's important to recognize that is a potential, because AOT can be extended in most states. Not all states, can usually just be extended time after time as long as necessary. So assuming that the person does finally engage in treatment, then there's a graduation ceremony, just like we do in many specialty docket programs. And if the person's not engaging in treatment, they're not participating, they're not showing up for their appointments, they're not taking their medication as prescribed, the treatment team has done everything they can to try and engage this person. The court has done everything they can to encourage that to happen, and they're just not having any luck. In that case, the case can be dismissed, and the prosecutor would be notified in that situation. And then the prosecutor can decide at that point whether or not they want to refile those original charges. In the event that the prosecutor is not willing to dismiss upon civil commitment up front, they may want to wait until after a full competency evaluation has been ordered. And then after that evaluation, if they've been found not to be competent to stand trial, the prosecutor at this point may decide, okay, I've got all the information I need. Now I'm going to, go ahead and dismiss and, upon civil commitment. Or in some instances, the prosecutor may say, nope, I want to have this person, restored to competency first, and then see if we can, if they're prepared for trial. And then assuming that even after that period of restoration, they're still not able to participate in the trial, competency has not been attained, the case must be dismissed under law, but there's still an opportunity for a petition to be filed for civil commitment with AOT. Unfortunately, in this instance, though, you're not saving any money, you're still in the same situation you would have been had you done this at the front end. Plus, the person has now lost some significant amount of time where they could have been getting the treatment that they needed, rather than the focus being on competency restoration. So if this sounds like something you think would work in your community, first and foremost, in order to be able to use this option, you must have an effective assisted outpatient treatment program. We have developed a roadmap that walks you through what that looks like. It's right here. We've got the link on the slides for you to educate yourself about it. If you're not sure if your community has AOT, we have a link on our website that's at the top of the page here. It's a state by state, and you can click on it. And all the programs that we are aware of are listed on that spreadsheet. If you have a program and it's not listed, please let us know so that we can add it to our resource library. Check that out. And then if this is something you're interested in becoming an AOT champion in your community, we're happy to assist however we can. We have amazing resources on our website, so check those out and get in touch with us. If you do have an AOT program and you want to pursue this option, we've got the handbook here. Again, we've got that linked on here, I believe. Well, you've got it in your chat box. But if this is something you're interested in doing, we're happy to walk with you side by side to get such a program implemented. You just need to read up and arm yourself with the facts and join forces with others in your community who think this is a good idea. And we know you can be successful. Excuse me. So we wanted to allow plenty of time for questions. So I'm going to go ahead and turn off this PowerPoint. And our whole team is available here. So if you have any questions related to this issue or AOT in general, now's the time to ask.
And please put questions in the Q&A pod or again in the chat box. We'll be monitoring both. All right, so we have a question. Can a petition for AOT be filed while a person is still facing criminal charges, or do the criminal charges have to be dropped before a civil court will consider a petition?
Amy, you might have a different view on this one, but I would say, yeah, if they're in criminal court, I would wait till, maybe make the case that the AOT is an alternative, but get them to dismiss the charges in the criminal court simultaneously. I don't know the benefit of having both.
There is no hard and fast rule that you can't have criminal charges while a petition is filed. But and depending on where you are in the country, petition to actual AOT can take a very long time. If someone's in jail, you have to get evaluators to the jail if they aren't already there. But the process in terms of providing the evidence to support the petition is still required. But so you don't have to wait. We would prefer that the charges be dismissed.
If somebody conversely, if somebody is in AOT and commits a minor offense while in AOT, it's not unusual for somebody on either the treatment team, the AOT monitor, or the judge to notify the other judge, just to let them know this person is in our program. We're working with them already. We've got this plan in place. We're sort of, we're working through it, but we're having some success. So sometimes if the judge knows that and the prosecutor knows that, they might be willing to dismiss those charges.
So Brooke, could you monitor the question, the Q&A pod while I monitor the chat?
Yes.
And you can go next.
Perfect. So Betsy, Zachary is asking if AOT requires a component of revocation.
I'm not sure I understand the question.
Zachary, if you want to provide a little more context. Oh, I didn't read down. Sounds like your question was already answered. We have another person asking, how do you come up with ideas, or what are some ways to help the person in AOT show up in court, therapy, etc.? And they say, for example, incentives.
There are a number of, there are a number of different ideas for that. Probably a lot of the folks on the phone can certainly chime in on what you do. I mean, certainly incentives do help. I know a lot of programs that offer incentive cards or snacks at the court, which is helpful. Just eventually, though, that encouragement and support from the team, is ultimately what gets the money to come back. We've also, if folks initially at the early outset don't show up, we've known situations where judges write them a note and says, "We really missed you in court. I'd love to, looking forward to seeing you at your next court date." The goal is really to try and identify what works best for that individual. If they're not comfortable coming to the courtroom, trying to figure out what their reluctance is. Sometimes you can do it initially, via, Zoom over the phone if you've got the case manager sitting with them. And then once they get to know the judge and the situation, they're more inclined to come back the next time. We've known one judge who actually went to the person's house and talked to him through the window. I know one situation where the individual was afraid to go to court because they were afraid to go through the metal detectors. So they came up with a plan to have them come in the back door and just kind of, wand them so that they were, safe to go into the building. So it really is not a one size fits all.
Awesome. Amy, do you want to go next, or do you want me to do another one from the Q&A?
You're on mute.
Oh,
yep. Sorry about that. There are some comments. Heather Vance, who's from Nevada County, California, says that sometimes judges will dismiss criminal charges upon successful completion of AOT, and that's absolutely true. However, we prefer that they dismiss the charges before they enter AOT, because AOT really isn't mental health court. It should be based on engagement strategies, and not the incentive should not be an external incentive. We really want to foster adherence, which is internally motivated. That's a whole nother webinar. But again, we prefer that the charges are dismissed prior to AOT. And I still have not gotten my arms around with prejudice, without prejudice. So if someone is not successful, we prefer that if it's necessary, that they refile the charges. So that option is still there, but it's not hanging over the person while they're in AOT.
and I can do the next question. Betsy, Sandy wants to confirm that AOT is completely separate from guardianship. Which,
yes,
yeah,
it is a separate, yes, completely separate concept. But that's not to say that somebody who's under guardianship wouldn't also benefit from AOT, because sometimes having that court order and having that judicial involvement and that black robe effect does benefit somebody. Just because you're in a guardianship doesn't mean that you're going to take medication because your guardian says you need to. Sometimes having, that judge say, that's part of your treatment plan and you need to do it, and that's sufficient, that helps. So, but yes, I mean, if you're not sure, if somebody's in your community and they're being considered for a guardianship, we would encourage you to ask yourself first, do they meet criteria for AOT? And is AOT another alternative for this individual? If so, we would suggest you start with AOT first, because as we see it is less restrictive. Usually time limited, guardianships tend to get extended over and over and over again. The goal of AOT is to get that individual to a point where they can care for themselves.
Thanks, Betsy. So Lori is asking, how do you determine if someone is unlikely to be restored to competency?
I'll leave that to the clinician on our team, but I believe there's sort of an assessment done at the jail, an initial assessment.
Excuse me, it depends on the system. Every system is different. Every state is different. And then many systems within the state behave differently depending on the state. At any rate, my experience as a clinician is in Ohio, and the way it worked there is that there was a specific entity that was made up of a psychologist and a psychiatrist, and they're the ones who went into the jail and did the evaluations. And then it is actually the court, they submit their evaluation to the court, and it's the court who decides whether to determine that someone is incompetent to stand trial. And at that point, they, if they're incompetent, then they wait for restoration. And restoration, again, is one of those things that happens very differently across the country. So.
Thank you, Amy. Do you want to go to one of the chat questions? So I have it in front of me, so I can do it too.
Would you, because I want to type an answer if you don't mind.
Perfect. So Betsy, Diana is asking, what if AOT is, oh, it just disappeared from me. 1 second. Sorry. What if AOT is ordered, but they live in a rural area that doesn't really have the resources or services that an AOT client would need? What happens?
Yeah, if you don't have the services that the participant needs, then it wouldn't be fair to put them under court order. So that's typically one of the requirements for AOT, is that the services that the individual needs are available in the community. So if they require something unusual or something that's just not part of the typical continuum of care, then maybe that's not a good alternative. But typically most of these folks just, having case management services, having a caring, treatment provider, and having a judge or magistrate who's available and responsive and encouraging them to, take their medication. Sometimes that's all that's necessary.
Thanks, Betsy. So Dawn is asking about a specific case, and she mentioned that in her county, her son, and sorry, it keeps disappearing when people add to the chat. Yes. But feel free to keep chatting, everyone. In her county, her son is on an AOT referral and has been 5150 2 times in the past 3 months. He was held at a psychiatric hospital for 8 days, brought back and released to the street. How often can this happen before real help happens?
And it doesn't sound like AOT. They're discharged to a treatment, with a treatment plan. Typically they meet with the court shortly after discharge, and they will walk through kind of what the their roles and responsibilities are as part of part of this program. If they're being released to the street, that's not AOT. I don't feel like I'm answering the question, but just to clarify that this is not that.
Makes sense. Deirdre is asking if people on AOT can be combined, or I guess AOT be combined with other programs that are already following a similar model. He says he's seeing competing duplication of efforts and very few people who meet the criteria outlined for candidates.
I think there are a lot of folks, a lot of programs that somebody who's on AOT is also automatically placed in the ACT program, the Assertive Community Treatment Program. So it might look like a duplication of efforts. The piece that's different though is this court order and having that judicial involvement. So that's the piece that separates this from other programs. Which, I don't believe most other mental health programs have. I don't know of any other mental health programs that, other than the criminal side, that offer that. But yeah, you don't need a separate ACT team for this population. So that's the beauty of AOT, is it really doesn't cost anything to provide these individuals treatment, because this is something that's already available in your communities. We're not suggesting you start anything new. You just plug them into your existing system where they belong and get them the help that they need based on what they need. But you don't need to create anything new. It's just that the difference here is you're monitoring them to make sure that they're following through, making sure that they're showing up for appointments, that they're taking their medication as prescribed, and that you're intervening as soon as they start to decompensate. Get them, back in court as quickly as possible. Get them review their treatment plan. If they don't like the medication they're on, then you need to sit down with them and their psychiatrist and figure out something different. Whatever is preventing them from adhering to their treatment, you want to address it quickly.
Right. And by the way, Zachary clarified about what he meant regarding revocation. He says consequence. But I think you answered that on your slide when you talked about AOT and PEACE. So we have two people asking kind of a similar question, which is a great question. And that's for places that don't have AOT programs, what are the barriers and the resistance to getting AOT programs in those areas?
Brooke, you did a really nice job answering this in an email the other day, so chime in. Probably misunderstanding about what it is. This notion that this is an expensive program to implement. The idea that they think that they need, an additional level of care, more treatment services that are already available. A belief that this is coercive and this is something we're doing to somebody and not something we're doing for somebody to help them get as I said, to gain independence. Others that I'm forgetting, Amy and Brooke.
I think maybe just not being aware of it as an option, or misconceptions about the amount of work that it takes. We're asking for collaboration between members of the community. And I think it's possible that, or I think it's probably likely in a lot of cases that the key collaborators have been kind of siloed from each other traditionally, depending on who they are. And so I think some communities are better at collaborating and making those connections than others.
Excuse me, Cassandra asks, is anybody really doing this?
Yeah.
Well, who's doing it and how are they doing it?
So there are a number of programs. Check out their website. You'll find that list around the country. Certainly, as Amy mentioned, we've got a number of examples in Ohio, but also Texas has several of their large cities are offering AOT. Kansas has at least 9 programs that we're familiar with. Kentucky is getting ready to implement statewide. I think in the months ahead, they have a number of programs there. Georgia has embraced AOT. 5 to 6 programs there, Brooke.
Yep.
Washington State is trying to implement statewide.
But are they doing dismiss?
Oh, sorry.
Not just programs.
Oh, sorry. So there are a number of programs where they're doing this, but not in a coordinated fashion. So already there, I mean, it happens all the time where somebody has been picked up, put in jail. The folks at the jail recognize that this is not an appropriate place for this person, that they're kind of stuck in this revolving door and they're not likely to be restored to competency. So they're talking to the civil court system and they're making arrangements for this individual to be, kind of have this not case transferred, but to dismiss and refer. But I am not aware of anyone who's doing it in this coordinated fashion that we envision, where it's sort of automatic, where, if they meet these criteria, then this is what happens. It's not like you have to look at each case individually and get, and everyone has to consult, but just sort of systematically, if this is the pattern, then let's automatically do this. So of course, yeah, and I see somebody's got Miami-Dade. So Miami-Dade does do some. The difference there is the only way to get into their AOT program in Miami-Dade is through the criminal justice system. We envision AOT really primarily intended to keep people out of the criminal justice system. So if they're kind of caught in that revolving door of hospitalizations, then we believe that's the ideal time to use AOT as a tool in the toolbox. The folks who fall through that crack and end up getting their case, end up, with a criminal charge in court, then AOT is certainly available. But ideally, we're keeping them out of that altogether, because those folks are typically in jail only because their treatment needs have not been met in the mental health system at that point. So they've already, they're not adhering to treatment. And so that's where they wind up. So we want to correct that. So.
Michelle Gambino asks, when a person has involuntary court order, can they leave the county?
They can. That's why it's so important. One of our building blocks you'll see in that white paper is to mentor neighboring counties, because a lot of people do, move back and forth over county lines. And so it's really important that if they move to the neighboring county, you can have that order transferred, or if they move within the state, you can, and there's a program in the county that they're moving to, you can transfer that order. If they move over state lines, then that's a little trickier. But yes, they still have that ability to move out of the area. Don't tell them that.
Yeah, don't tell them that.
Dave is asking a great question, which is, when is it appropriate to terminate an AOT commitment?
Amy?
When the person is able to associate the quality of their life with their participation in treatment. So what I'm not saying is when the person has insight into their mental illness. There are many folks who respond to antipsychotics, which do wonderful things for hallucinations, delusions. They're their baseline improves, but they still don't have insight, and they never will. So it really has to be when the person is willing to come to treatment. And so what I recommend is slowly weaning someone off the support, the intensive support that they get while they're in AOT, instead of picking them up and bringing them to their appointments. Let's see if they come on their own. And other, just kind of back away. Not from treatment. I mean, they should still get all the case management and the psychiatric medication management that they do in community mental health treatment. But so that's my simple answer. There are some people, and Betsy alluded to this, is that there are some people who will only take their medication because of the court order. And it is not considered unsuccessful if somebody has to remain on a court order. We know there are folks that have been on a court order for 15 or more years. They're doing well in the community, but as soon as you take away that court order, they're going to disengage. So it's very individualized.
And I think this is a California specific question, because I believe 5150 is from California. So we may not be able to answer this, Dawn, but Dawn, who asked about her son earlier, is asking, when does AOT interact while the 5150 hold takes place when that person has an AOT referral?
Well, if they're the 5150, if I recall, is involuntary treatment hold. It's not the actual order. Or you know what? I need someone from California to answer that.
We've got some experts from California.
Yeah, if anyone on the call can help us out, please go ahead. So Wendy is asking, are AOT programs specific, like ACT teams, or can they be a mental health provider who provides outpatient services in general?
I'm sorry, can you say that one more time, Brooke?
Yes, our AOT programs specific, and I think what Wendy is asking is, do you need a separate team for AOT? So she's asking, are AOT programs specific, like ACT teams, or can they be a mental health provider who provides outpatient services in general?
Yeah, absolutely. The second one. There are some, some programs who are particularly in larger communities where they do have a kind of a dedicated team that just works on AOT. So it depends in some regard to the size of your community, but no, you don't need a specific group of folks for this. In fact, we sometimes think it's better that you don't. That is much easier to integrate them back into the treatment program if they're seeing the same person that they're going to continue seeing even after the order goes away.
Got it. Susan Collins is asking, is what would happen if someone got arrested out of state? And presumably they're on AOT.
So they're on AOT in their county of residence and they're out of state and they've committed an offense, then they would have to answer to their charge in that community, wherever they committed the offense. unless they have some kind of arrangement where they're transferring them back to address charges there, but yeah.
Got it.
So, yeah, that is such a difficult situation, because coordination within a state between counties is difficult enough, but when you are trying to coordinate between states, it raises it to a whole nother level.
And Amy, I'll interrupt you there. I made an assumption about Susan's question, which was wrong. She's talking about for people who are not on AOT but need it. So someone who is they're not on AOT yet, and they're arrested in a different state than their state of residence.
Right, and the same holds. They still need to answer to the charges in the county that they offended. It is not impossible to do this across state lines, especially when you have cities that kind of straddle state lines and the systems are used to working together. But as soon as the criminal legal system is involved, it becomes much more difficult.
Right. And Wendy is also asking, is a person ordered to AOT, or I think she means is a person ordered to a specific provider? Could they choose so I guess if there were multiple providers doing AOT in the same community, would the person have a choice?
I think that varies from community to community. Ideally, the answer is yes. If that provider is willing to participate with the program and is willing to, they would have to, say they'd be willing to submit regular reports, because there's regular reports required to the court, usually on a monthly basis. If they start to decompensate or there's a concern, they need to notify typically what we call the AOT monitor, who's been designated to monitor that individual in the community. So I'd say yes. I think that, ideally everybody would work to make that a success. As I mentioned, there are some programs that have dedicated teams. Typically, these folks aren't engaged in treatment. They don't have a provider. That's how they wound up in the situation. So in that case, they're typically kind of assigned to the, to that provider who's been identified sort of as the lead on this. But if they already have an established relationship, then we hope that the program does everything they can to make sure that that continues.
And one of the oldest AOT programs in Ohio is in a medium-sized county, and they utilize all of their providers. When I was working, there was only one provider in provider of services for this population. So it was everybody came to us. And I will say that it was unusual that we didn't know the person. We didn't have some history. Because as Betsy said, a lot of times these folks are friendly faces. They come and go. So.
Well, we've got one more question in the Q&A, and that's from Jane. And I want to say too that Jane, our colleague Jerry Clark, who's on the call, just put a little note in the chat saying that if families seeking support to navigate specific situations can reach out through Treatment Advocacy Center's helpline, which I would definitely recommend you do. The advocacy team is fantastic, and they provide a lot of excellent support to families. But I will pose your question too, because I'm wondering if the group can help you identify maybe just the first step to help with your situation. So Jane's son has been in and out of jails and hospitals for the past 20 years. He was diagnosed in 2000 with schizoaffective and Asperger's. He has anosognosia. He does not think he's sick or that he has committed felonies. He's currently in the state hospital and for the past year has been there or in jail. What can be done for him when he's released again if there's no beds and there are no beds available when he's back in jail?
Unfortunately, again, Brooke just wrote a great letter to a tech supporter who had a very similar question. And AOT is not a panacea. AOT does not make up for an under-resourced mental health system. AOT works when you have the resources, at least a minimum level of resources available. I read that question and I don't believe you mentioned whether the person will come out of the hospital on an outpatient order, but it is my hope that your son receives the intensive services that he will require and that your community will step up, because clearly it's in their best interest to do so. It's convincing them that that is the case.
And we do have one more question. Edmund is asking if SMI patients in rural counties can be served through virtual telehealth, Zoom, or similar such options.
That's really out of our scope of practice. But I'm just curious, Shanti, have you read any research comparing telehealth to in-person services? And it's okay to say no.
Yeah, I think off of the top of my head, especially since the pandemic, there has been research that suggests that telehealth may work for some people and many people. But I think especially when it comes to some of the people we're talking about who might be eligible for AOT are familiar faces in our communities. I think it may vary person to person. A lot of it has to do with, does the person have somebody who can help them with the technology? Are they comfortable? Is this an area of paranoia? So I think that it is definitely something that I'm looking forward to seeing how the field progresses, since it is more accessible for many, but also presents more barriers for some.
I can tell you, at least in the programs I'm familiar with in Ohio, it's in the rural counties, more and more of them are exploring that as an option because they have no other choice. They have no psychiatrist available, no hospitals that can take their loved ones. So they're looking at using AOT as a step up from the community, and then using a telepsychiatrist to get, to do the evaluation. So they have that documentation to make the case to the court. So the jury's still out in terms of how that looks, but it's certainly something that I know a lot of communities are entertaining. So we'll watch it carefully and report back.
I will say, though, that case management is not a service that can be done by telehealth. So AOT requires successful AOT programs do assertive outreach to their participants, and that is not something that can be done via telehealth. And again, in my experience as a case manager, I know I saw my clients much more frequently than they saw the psychiatrist. So telehealth isn't going to help with that part. Neither is office-based services. Even case managers that are office-based, they can be helpful, but if these folks are not walking in your door, So if you don't have someone to join alongside them, do the outreach that's necessary. It's going to be a real struggle to have them succeed.
Also, I know this might sound wild to some people because it's 2024, but not everyone has a smartphone or even a phone, depending on their situation. So it can be a barrier. Last call for questions.
Well, thank you, everybody. Appreciate those who stayed with us and asked questions. Always feel free to reach out at AOT@treatmentadvocacycenter.org. We can continue the conversation there if you like. All right. Thank you. Bye-bye.